Hello, welcome to Business Law 1, Unit 4, and the topic is sales. I will be covering the first part of this lecture online and the second part of the lecture in class. So let's begin. All right, we begin with the scope of sales. What's the background to sales? Why is sales different? When we're talking about a sales contract, we are speaking specifically about the sale of goods. Goods are different from real estate or services. They are tangible, movable objects that have a special set of laws found in the Uniform Commercial Code. So that's one of the key things that you want to begin with. They are also sold by merchants and non-merchants, and we need to understand the distinction between those two. A merchant deals in the goods of that particular type, holds themselves out as having special knowledge about those goods, and either acts as a broker or agent or other intermediary, and holds himself out as having the status of being a merchant with extra expertise. And so they are treated differently under the law than a non-merchant. One of the big reasons why we have a different set of laws for the sale of goods compared to sale of real estate or services is that we want the wheels of commerce to move really fast in the United States. And so what we find is that the laws regarding the sale of goods is much looser, less rigid, so that we can just continue to do business and not get too hung up on contracts. All right, so you'll see a couple of questions in that area. Next, I want to move to the topic of offer and acceptance. All right. I had already mentioned that the UCC is much more loose and less rigid. And so what we have in the distinguishment of the laws is that terms such as price term, delivery term, payment term, duration of an ongoing contract, the amount of quantity that's being ordered, that many of these terms can be left open, that is not addressed, and we still have a contract. All right. So if I were to ask you, according to the UCC, one or more open terms will always cause a sale or lease contract to fail for indefiniteness, you'd be able to answer that that'd be false. Now there is the exception to the rule, of course, and that is with regards to quantity. If no quantity is listed within the terms of the contract, as a general rule, there is no contract. Now there are exceptions to that exception. For example, output contracts or requirement contracts. So you may want to read up on those a little more specifically. All right, with regards to acceptance, once again, the UCC basically fills in the contract terms if the parties did not address it in their original contract. And so what we see are a lot of rules on how to fill in the contract if the contract is silent. All right. So let's begin to talk about acceptance, and this is, I'm looking specifically at 4.1 on the outline, shipment of non-conforming goods. What if the seller has shipped goods that are not what was specifically ordered? Well, when that occurs, that constitutes both an acceptance and a breach of the contractor, of the contract on behalf of the seller. All right? The exception to that is if the seller ships accommodation goods. Note, from the buyer, this is not an acceptance, but it's an offer of other goods. In other words, it's a counter offer. All right? So, let me give you an example. Let's say that ABC, okay, offers 10 cases of diet-free Pepsi, okay, and if from, let's say, the Pepsi Corporation, if the Pepsi Corporation ships those same number of cases, but instead of shipping diet, they ship regular Pepsis. Well, the shipment acts as what? The shipment acts as both an acceptance of the offer, but it's also a breach of the offer. All right? Now, let's tweak the facts a little bit. And what if they ship accommodating goods? That is, they include a note that says, we're out of Diet Pepsi, but we're going to ship you this other case of Pepsi as an accommodation. All right? So same facts as before. Let's go through an example. Same facts as before, except the Pepsi company notifies them that they're shipping not what they specifically asked for, the Diet Pepsi, but the regular Pepsis. All right. If that occurs, what is this? Is this an acceptance? Is this a counteroffer, a breach, or a rejection? Well, if they include an accommodation note, then it's a counteroffer. All right. Let's talk about the next topic, which is additional terms. When we're dealing with merchants, each merchant normally has their own boilerplate language of shipping out goods or accepting goods. All right. So we have different rules for non-merchants than we do with merchants contracting with other merchants. You need to be aware of that. So on your outline, when it says rules, when one party or both parties are non-merchants, a contract formed according to the terms of the original offer and not the additional terms is what the offer presents. All right, so you need to understand when you're dealing with a non-merchant, then the original terms control. If you're dealing with both parties being merchants, then we need to follow these sets of rules. All right, additional terms become part of the contract unless the original offer limits the acceptance of the terms, or 2, the new terms materially change the contract, or 3, the offeror objects to the changed terms. So you're going to see a question with regards between two merchants and how they are offering and accepting, and you need to understand which rules apply. All right. Moving on from there, we want to talk about parole evidence. Parole evidence is when there is a dispute between the parties with regards to the contract. Can one of the parties invite outside evidence to help us understand what the contract says? Well, the general rule with regards to parole evidence is that prior course of dealings that establish a common basis for the parties' understanding can be admissible as parole evidence. Now, under common law, it would not be permissible, but with the UCC, with regard to the sale of goods, prior course of dealings can be introduced to help us understand the contract. The next topic I'd like to talk about is called unconscionability. That is, when will the court rule that the terms of the contract are so odious and that they take unfair advantage of the different bargaining position of the parties, that the court would declare the contract to be unconscionable? Well, We talked about that in previous sessions, and normally what we're looking at is there is a relationship, a subservient, a dominant relationship in the contract between the contract parties, and that the terms are so egregious that the court could declare that it's unconscionable. Well, in the UCC, we tweaked that just a little bit, and the court can refuse to enforce the whole contract if they determine it to be unconscionable. They can enforce the remainder of the contract that's not unconscionable, or they can limit the application of the unconscionable term to avoid the unconscionable result. So the court has the discretion to either reject the entire contract or to slice and dice it so that it's not unconscionable. The last topic we want to cover is risk of loss. All right? When the goods are to be delivered from the seller to the buyer, there are three things that need to occur. First, we need to identify the goods to allow the title to pass to the buyer. Second, we need to pass the passage of title. Once title transfers, this allows the risk of the loss to transfer to the buyer. And 3, risk of loss. This allows the buyer to insure the goods, and the right to recover from third parties. For example, they could sue the seller, the warehouse, or the trucking company once they have the title and they bear the risk of loss. Then they can then countersue if somebody else caused the risk of loss. When we talk about the delivery with the movement of goods, then we look at the carrier cases, and there are two types of contracts with regards to carrier issues. There's shipment contracts, and then there's destination contracts. All right, so the risk of with a shipment contract, the risk of loss passes to the buyer when the goods are loaded onto the carrier. When it's a destination contract, the risk of loss passes to the buyer when the goods are tendered to the buyer and arrives at the loading dock destination. So you're going to see a few questions. For example, let me ask you this. When the risk of loss for a seller is the same for the destination and shipment contract. Let me read that again. Risk of loss for the seller is the same for destination contracts and shipment contracts. You would know that's not true, okay? Because by definition, the risk of loss passes differently between a destination contract and a shipment contract. Let me ask you another question. A bailee, who is a bailee? A bailee is a third party who holds the goods for the seller to be received by the buyer. These are sometimes warehouses that hold these goods. Well, a bailee is a third party who holds the goods until the buyer has the right to receive the goods. Is that a true or false statement? Well, you would know it'd be a true statement. All right. There are other topics not specifically covered in this, so be sure to read the whole chapter and read the whole outline. But you will have approximately 12 questions related to this segment. If you have any questions when we come back to class, I'd be glad to answer them. Call me anytime. Thanks. Bye.